Welcome back to Canadian Justice, where we're discussing a recent BC Court of Appeal decision in Cambie Surgeries and British Columbia, a case that my organization is invested in. Now, Joanna, today we're focusing on the legal reasoning in the decision in the Cambie Appeal. So let's start with the majority. Can you tell me what the majority in the Court of Appeal found about whether patients' Section 7 right to life and security of person was being violated by this prohibition on private insurance or dual practice, the restriction on private healthcare in BC?
Yeah, so as Craig just mentioned, there are two prongs to a Section 7 violation. So the majority did find that the rights to life and security of the person were violated, but they also found that these violations occurred in accordance with the principles of fundamental justice. So in the result, there was no Section 7 violation. And in that query around fundamental justice, we're looking at whether the law is arbitrary, overbroad, or grossly disproportionate.
So, Joanna, how significant is it that the court found that the right to life here was violated, that these laws could result in patients actually dying? And is that finding different by the Court of Appeal? Is that different from the trial decision?
So first of all, it is different from the trial decision. The trial judge found of the BC Supreme Court found that there was no evidence that lengthy waits for care had led to any identifiable specific individual's death. So first of all, I think just on its face, the fact that the Court of Appeal disagreed with that finding, disagreed that there was no violation of the right to life, of course, is hugely significant. And their reasoning was that it's not necessary to prove that a specific person who's before the court experienced the risk of death, but they found that on the record, there was clear lots of expert evidence that could identify what they call a class of persons for whom lengthy wait times increase the risk of death, which I think just accords with our common sense. We know that the longer you wait for certain types of conditions, the more you're at risk of adverse outcomes, including death.
So the Court of Appeal found that these laws could infringe the right to life and security of person. But as Craig mentioned, they found that this was consistent with the principles of fundamental justice. So, Craig, for our viewers who may not be familiar with this term, what does that mean in law? What are the principles of fundamental justice, and how do they interact with our guaranteed right to life and security of person?
As Joanna mentioned, in this context, there really are three principles that the courts assess and analyze, and that is whether the law is arbitrary, whether it's overbroad, and whether it's grossly disproportionate. And so as Section 7 has been interpreted by the courts, Section 7 tolerates deprivations of life, liberty, or security of the person, provided that the law that brings about that deprivation is not either arbitrary, overbroad, or grossly disproportionate. And so in this particular case, as Joanna explained, while the court found deprivations of life and security of the person, the court concluded that the laws were not either arbitrary, overbroad, or grossly disproportionate. That's the majority view in the Court of Appeal.
Now, Joanna, it does seem counterintuitive that a government policy could actually violate the right to life, but still be consistent with the principles of fundamental justice. Basically, the court is saying, yes, we acknowledge that this law could kill people. So how could that be fundamentally just? This is confusing for a lot of people.
Yeah, so the principles of fundamental justice analysis, I first of all agree that there's a lot of dissonance here, and there's a lot of apparent dissonance, and we'll get into the concurring decision that makes that a bit more explicit. But essentially, what the court does is they look at the law's purpose to look at this principles of fundamental justice analysis, and they end up saying that its purpose itself is to govern all healthcare in British Columbia, not just in the public care system, but all delivered healthcare. And if you look at it from that perspective, then it's not arbitrary or overbroad. But they're essentially saying that in this finding, some laws are rightly and in accordance with the principles of fundamental justice sacrificed to some type of greater good that the law is aimed at.
Craig, we've only got about 30 seconds, but your perspective on that.
Yeah, I think it really is a question of the connection and the match between the law's purpose and its effects. And in this particular case, the majority felt that the connection or the match between the purpose and effects were not sufficiently out of line to strike down the law under Section 7.
Now, there was a concurring decision in this case. We've got to go to commercial break now, but a concurrence is the judge found the same thing, had the same outcome, but for different reasons. And those reasons in a concurrence are really fascinating and shed a lot of light onto some of these issues. So we've got to go to break, but we will discuss that concurrence when we come back.